Further hearing in the appeals of Competition and Markets Authority against Flynn Pharma Ltd and another, and Pfizer Inc and another.
Sir James, good morning.
My lords, my lady, good morning. There's still a fair bit to get through in my Sisyphean efforts. I was going to complete the spin through the case law, if I may. Perin Panathan got halfway through Lord Neuberger's judgment. That is, if you could pick it up again, please, at page 1296. And I just wanted to draw your attention to the final sentence of paragraph 63, which is an important conclusion that Lord Neuberger reaches, having conducted an analysis of the case law, in effect saying that the fact that the rationales apply just as much in his context as in other contexts leads to the conclusion you see at the tail end of paragraph 63. And you'll have noted that he'd earlier described Lord Bingham's observations, first sentence of paragraph 61, as being based, as he put it, on policy and justice, but also supported by previous High Court decisions and so on. Then at 65, he examines the breadth and the reach of the principles or rules established by that consistent case law. In essence, he concludes that it's a principle that applies, or a set of principles that apply across the width of its logic. And so you see the reach described in the middle of the paragraph. Any case where the police or a regulatory authority was carrying through what was essentially an administrative decision, by which I understand to mean, I'm quoting from paragraph 65, I understand to mean the performance of one of its regulatory functions, and where the question of cost was governed by section 64. And to the same effect, we would note, same description of the breadth of the principle in paragraph 73 by the letter B. Lord Bingham's three principles should apply where a regulatory body is reasonably carrying out its functions in court proceedings, at least where the rules of that court contain no presumption or principle that costs follow the event. And then going on, the effect of that reasoning is that just because a disciplinary body's functions have to be carried out before a tribunal with the power to order costs, it does not follow that there is a presumption that the tribunal ought to order the disciplinary body to pay, to pay, and so on. So it's against that backdrop that he comes to the dilemma or the question as to the starting points that he posed in paragraph 75, to which I drew attention yesterday. And in answering that question, he's already given the answer of principle in effect in paras 63, 64 and 73. And we note for good measure that he's added in the incoherence of not letting the principle run across the breadth of its logic in paragraph 74. If we were to hold that Lord Bingham's principles do not apply in a case such as the proper approach to the question of costs in regulatory matters, note that phrase again, it would fairly be seen to be incoherent or at least inconsistent. And then he gives the answer to the question of principle that he poses, both on the basis of authority, see final sentence of paragraph 75, and on the basis of principle in paragraphs 76 and 77. Can I just invite you to refresh your memories of 76 and 77 without my reading them out?
What does it mean? It's not as if the other party would have no right to recover costs in such a case?
I think
There's
he's,
too many negatives in that sentence for me to...
I think he's there referring to the existence of the good reason principle, or the exception that you can take all the circumstances into account, and if there's good reason to go the other way, you do. It's only a starting point. So that's Lord Newburger. That's Lord Newburger. BT and Ofcom then, as I said yesterday, I'm going to pull these together in some propositions, if I may, after the go-through, but it's easier to take them in one run, as it were, because they are all, to, I respectfully submit, to similar effect. BT and Ofcom starts at 1189, a decision of the Court of Appeal, as you see on page 1189. This was November 2018, and of course it concerned the cat. The issue is described at paragraph 1. On page 1190, and you will see the nature of the cat rules. And the position which had been adopted by the cat in the penultimate sentence of paragraph 11 on page 1191. Just to flick back so you see the nature of the core issue that was being argued about. The various parties' submissions were set out and summarised at paragraphs 3 and 4 of the judgment.
So can I just be clear, is this what we've been calling regulatory appeal?
Yes, it is.
Is this, I think my understanding of this is that Ofcom is required to carry out these reviews periodically of certain aspects of the market or of the operator's profitability or pricing, and this was one of those periodic reviews in which it comes to various conclusions, and BT had challenged that. So it wasn't a sort of a proceeding against BT as such?
No, it wasn't like our case, but it was exactly as my lady describes, with, if I've understood it correctly, then some findings about how the market should operate, which were obviously had the capacity to impinge and potentially impinge in serious ways on the market operators, and it was that led them in their commercial interest, as it were, to challenge it.
Was it only BT which challenged it, or...?
That I'm afraid I don't know, but someone will be able to find the answer to that. Others as well, I'm told.
Yes, usually you have a full court when you're dealing with these.
Oh, okay. Well, sounds like there's a disagreement.
Oh.
Let's find out. There must be a factual answer to that
but
question.
it's a periodic market review on connectivity, and Ofcom then sets out its results, and whoever's aggrieved by that can challenge it.
My lady, yes. And so, of course, it isn't directly necessarily like our 1998 Act appeals with a penalty imposed and so on, but the economic impacts can be just as serious, is perhaps the riposte point. But what the Court of Appeal do...
So sorry, just so that I get it clear. I had in mind that what I thought we were calling regulatory appeals were where two market participants had some sort of dispute and they go to the CMA. I appreciate this is Ofcom. So this sounds like something rather different.
I'm sorry, then the terminology is my confusion. It's not a dispute resolution case.
In paragraph 4, the Court of Appeal in this case distinguished between dispute resolution appeals and what they're all calling regulatory.
They're calling this a regulatory appeal in the middle of paragraph 4. Yeah.
And so there are various different types. You've got a position where they're effectively acting qua arbitrator or dispute resolver. You've got the situation with which this was concerned, which was exactly as my lady described, as I understand it, and then you've got our sort of case.
Well, and that our sort of case could also be an Ofcom sort of case, because I think is Ofcom a concurrent competition enforcer?
And there are a few of them, as you know.
But is just one final question, not necessarily, but is the standard of review in one of these regulatory appeals against a periodic market review, is that a judicial review or a merits test?
It was then merits, it is now JR.
Yes. Okay.
There are others who know these regimes better than I do, but that's my understanding of it. So the Court of Appeal then traced through the many authorities from paragraphs 28 and following, or 29 and following perhaps, and you'll see that, unsurprisingly, the case they start with is Booth, just above paragraph 29, and they conduct a very extensive analysis, both of the, if I can call them that, the common law authorities and also the CAT authorities. So you see the next one the court considers above paragraph 32 is the RBS backhaul case. So extensive analysis of all of those decisions, and I'm not going to take time going through them here, but the real question for the court, it might be thought, was whether or not the line of authority that is represented by Booth and following is actually consistent with what the CAT had been doing in the other authorities that were analysed by the Court of Appeal. So they come to the issues for determination on page 1206 at paragraph 63. Against the backdrop of that potential dissonance between the lines or strands of authority, perhaps exemplified, sorry to jump back a bit, but if you go back to paragraph 61, you'll see the quotation from Pay TV, the CAT authority of Pay TV, and you'll see, in essence, the approach that CAT had been adopting. So the issues then at 63 is identified, and the first of them they dealt with at paragraph 64 and following. It's perhaps worth noting that the court specifically took into account, see paragraph 64, the point that we discussed a little bit yesterday, that the CAT is a specialist tribunal. And I was taking Mr. Howell to task for citing masters of their own procedure without the rest of the sentence. So you might as well see the rest of the sentence. It's halfway through paragraph 64, with the proviso always provided that the procedure is not in conflict with any applicable legal principles, which in essence the court held it had been. They also took into account, and it's a matter I'll come back to, but they also took into account the fact that the CAT is a UK tribunal, again a matter I was discussing with Lord Stevens and Lord Hodge was interested in yesterday for understandable reasons, and you'll see how they dealt with that at paragraph 65. Just simply to note in parentheses opposite that paragraph that the Court of Appeal below in our case was also well alive to that fact, because it was the lead-in to their analysis of the single Scottish case that had been cited to them, the Ahmed Sheikh case, at paragraphs 42 and 43 of the Court of Appeal's judgment below. But both courts of appeal considered and took account of the fact that the CAT was a UK-wide tribunal. I'll come back to the significance of that when I pull together the propositions, but just so you note it. So the first main issue, considered 64 onwards, was whether or not the CAT had correctly understood and applied the reasoning in the Booth line. And the first conclusion that they reached, you see recorded at paragraph 66 on page 1207. which was that the language used in each of Bradford, Baxendale, Walker and Panathan is in very general terms that is capable of direct, if analogous, application to the circumstances of the present case. And then cut to the final sentence, it's enough to say that in each of these authorities the courts contemplated that the principles they were enunciating would be of significance in application in other areas. So that's the first of their many conclusions in relation to issue 1. Secondly, they concluded, and this is paragraph 67, 68 and 69 by reference to the analysis of each of Bradford, Baxendale, Walker and Panathan, that the reasoning bore that out. It was reasoning which was generally applicable to the cases or contexts falling within it. So, for example, in relation to Lord Bingham's third proposition, treated and dealt with in paragraph 67, the conclusion of that paragraph is there can be no doubt that the proposition resonates and must be taken to be of some importance in the situation that faces this court. And likewise, in the beginning of paragraph 69, Perrin Panathan, Lord Newburgh expressed themselves in terms wide enough to be of relevance to the competition arena. And then a couple of sentences on, moreover, the terms used by Lord Newburgh at 65, 73 and 76 were obviously broad enough to be read across to the cat.
I think we were shown paragraph 19 that this was a case where there was evidence that Ofcom might be chilled from taking regulatory action if costs were awarded against it.
My Lord, there was some, but it hadn't been probed, and there's a debate around what the reasons were for the remittal back to the cat from the Court of Appeal, but there definitely was some evidence. I think I'm right in saying, and again it's a point I'll come back to when I deal with chilling effects, that this case is unique in that respect. In no other case in this line of authority was direct evidence received about that matter. But I think Ms. Polly Weitzman produced a statement in this case about the particular position in relation to Ofcom. That may or may not have been one of the reasons for the...
I mean, is the nature of that evidence the kind of material that Mr. Brearley was showing us about how it's funded, the number of decisions it takes, or is it legal counsel saying hand on heart, I would be chilled if I thought that Ofcom would be ordered to pay the costs?
I'm afraid I don't know the answer to that because I've never seen it, but you're right, it raises a question as to how one would go about doing it.
That's a kind of odd thing for legal counsel to say, and of course impossible for them. They would be talking about some future situation.
I would be chilled.
I would be chilled, yes. 19
gives some flavour of it, but,
yes.
but it's a strange mechanism of evidence by assertion or the other way around.
Yes.
If it's that.
Yes.
If you're providing a context which says how this is how we're funded, and I'll have to come back to that in relation to our situation, that might be rather different, because it provides some context from which the court can judge the reality of it. I'm not sure how much the court would truly be assisted by an assertion that you would in future be chilled. Easily made, difficult to disprove.
Right.
Yeah, I'm not sure. I'm looking at paragraph 19 that was the nature of the evidence. It's just a short summary there, but clearly it wasn't just an assertion. There was reference to the budget constraints upon Ofcom, and in the light of those, the potentially damaging effect that a higher award of costs would have.
My Lord, yes, I wasn't seeking in any sense or shape or form to diss the propriety of Ms. Weitzman's evidence. It plainly did include that contextual material.
Yes, all right, thank you.
But the broader question is how much the court would actually be assisted by an assertion.
Well, there are different ways that one can put that sort of material before the court.
There are. But the conclusion, to go back to the reasoning of the Court of Appeal in BT and Ofcom, the conclusion on this first issue is really encapsulated in paragraphs 71 and 72. I could just, on page 1208, if I can just invite you again to cast your eye down those paragraphs rather than my reading them out. So they in effect conclude that the CAT had been wrong to reject that line of authority as of no relevance. It was of relevance. The principles in the Booth line were applicable, at least prima facie. And on that basis, the question and the approach that the CAT should have taken were as set out in paragraph 72. And that position had not been considered on that basis. Then the second issue is picked up above paragraph 73, and you'll note the final sentence of paragraph 74, insofar as the regulator is acting in that capacity in bringing or resisting proceedings. That is an important consideration. I should add in parentheses opposite that, I don't understand anyone in this appeal to be saying that there's any doubt about that proposition. I have an argument about whether it's a starting point and whether it's important should lead to it being a starting point. But that proposition appears to be uncontroversial. And then there's a conclusion of a general kind in paragraph 78, as you see, reflecting what the court had found earlier. And then key conclusions, perhaps. In 79, including in particular the sentence in the last two lines on page 1209. Moreover, the CAT relied there correctly, we think, on the fact that wider public interests were at stake. The CAT also thought, going on, again correctly, that an order for costs against Ofcom could potentially have a chilling effect on its activities, even though that would not by itself have been sufficient to deprive Hutchinson 3G of its costs. And then 81, in which they cite from the number a CAT decision which broadly echoes, if I may respectfully say so, broadly echoes the thinking of Lord Newburger at paragraph 59, the benefits of there being a consistent approach. And then the court felt it right, setting out the proposition of the key proposition of principle, which is at the heart of this case, to emphasise in their conclusion, or to reiterate in their conclusion, the fact that they did in paragraph 83. We need only reiterate the importance of the fact that the regulator is acting in that capacity in bringing or resisting proceedings. Thus, if Ofcom has acted purely in its regulatory capacity in prosecuting or resisting a claim before the CAT, and its actions are reasonable and in the public interest, it's hard to see why one would start with a predisposition to award costs against it, even if it were unsuccessful. So that's a broad conclusion, as you see. And then they address the consequences, which the Court of Appeal puzzled over in our case, and remitted.
In paragraph 80, the Court of Appeal says the CAT also thought again correctly that an order for costs against Ofcom could potentially have a chilling effect on its activities. So
Yeah.
it seems to have been treated as an established fact by whatever evidence that it would have or could have such an effect.
It looks like that, but that then prompts the question, which is the dilemma which the Court of Appeal below grappled with, which is, was it part of the remittal to consider the evidence in more detail, or were there other reasons for that? But, my Lord, you're right. They certainly do draw attention to that, and one can make the broader point on the back of that, which is that, that's a point I flagged yesterday, which is that the Court of Appeal was very, very clear here that the line of authority was engaged, and that conclusion, whatever else the remittal might have done, was not dependent upon the outcome of the remittal. So, my Lords, my Lady, that's the case law. I'm sorry it's rather a laborious way of doing it, but I hope you'll understand why I've gone through each of the cases to show you how the principle has developed. Can I try and pull the propositions together? And I do so against the backdrop of the broad submission, which is that the High Court and the Court of Appeal cases that we've gone through favour, I submit, a broad principle applicable to bodies acting in a regulatory capacity, including inter alia in the competition arena, to take the Court of Appeal's wording, in bringing or resisting proceedings in courts or tribunals governed by rules that confer a wide discretion as to costs, with no starting point laid down that costs should follow the event in the body of the rules. That's the broad approach of that case law. And there are, we submit, 6 key propositions or 6 key elements to be derived from that case law. But firstly, there is a distinction between a context in which the relevant cost rules are, if I can use the shorthand, open-ended, as compared to setting out a costs follow the event general rule. And a couple of sub-points under that one. First, there is no costs follow the event rule or starting point in the cost rules under consideration here. Whatever else may or may not furnish a starting point, assuming a starting point is desirable for all the reasons given by Lord Newburger, or general rule or presumption, that is not it. CFE is not it. It's plain that that has been deliberately left out of the scheme of the rules. And it's important to make that clear, because the approach, and I'll come to the detail in due course, the approach to which the CAT jurisprudence has gone or drifted is that CFE is indeed the presumptive starting point. Whether or not there's another starting point we can argue about, and I'll make some submissions about, but that cannot be it, I respectfully submit. Secondly, the same point, absence or omission from the rules, cannot be made, or at any event cannot be made with anything like the same force, in relation to the significance of the regulator acting as such. And that is because the rules sit in the context of the common law principles and approach described, refined, considered in all the case law we've gone through. There is, to put the point in a slightly different way, no provision governing costs in which the Booth line has been held to apply that has specified that the presumption is that the regulator should not pay costs unless there's good reason not to. But nevertheless, and despite that absence, the Booth line has been held to apply. That's the first point. The second point is that it is, we submit, key to recognise, and a factor of considerable importance irrespective of the starting point debate, it is key to recognise that the body against whom the costs order is sought is a regulator exercising functions in the public interest. The importance of that factor is recognised absolutely throughout the line of authority that you've seen. It's the leitmotif within it. You saw it referred to in terms of of being an important factor in Uxbridge, in Totnes, in Goodman, in Gorloff, Mr. Justice Toulson in Nestling, in Baxendale Water, where it was described at paragraph 39 as a crucial feature. In Nestling, Mr. Justice Toulson at paragraph 11 described it as plainly a most important factor, 2938. Crucial factor in Baxendale Walker is 1180, para 39. You saw it recognised again by Lord Newburger in Perrin-Panathan, 76 at 1300, and repeatedly in BT and Ofcom by the Court of Appeal, see paragraphs 72, 74 and 83. You just come from 83. We reiterate, said the Court of Appeal, the importance of the fact that the regulator is acting in that capacity in bringing or resisting proceedings, page 1210. And it isn't just this line of authority. That is a distinction and a feature which has been consistently recognised by the courts. I started with the quotation from Lord Sumption in Gallagher at paragraph 46, page 3055. Don't invite you to go back to it. You will recall that he said a competition authority is not an ordinary litigant but a public authority charged with enforcing the law. And you get the same idea and the same thinking from the Supreme Court's decision in 2013 in Financial Services Authority against Sinaloa Gold, which starts on page 2203. And this was all about the giving of cross-undertakings in damages in the context of Morava injunctions. And the relevant paragraphs for present purposes are paragraphs 30 and 31 on page 2218. Can I just invite you to read those two paragraphs yourselves, so 2218, paras 30 and 31. So you'll see the basic thinking, which we respectfully submit is very, very similar to the thinking in the line of authority that I've taken you through, emphasising that distinction between the position of a public litigator, if you will, and a private litigator. It's the same point that the Court of Appeal were thinking about in Baxendale Walker at paragraph 35 on page 1178. So I emphasise this distinction and the importance of this factor because I say just how significant and how that significance should play into a set of principles within the cost regime can that be open to debate, and I'll come to in the next set of propositions. But it is, on any view, a factor of real importance, not to be ignored as irrelevant or outside the territory. And that was, in effect, the dilemma that the Court of Appeal was grappling with in BT and Ofcom.
I mean, if one has a public authority with a limited or constrained budget, and the question is whether a cross-undertaking in damages is to be given, in effect, for potentially unlimited damages if they get it wrong, it's quite easy to see that there may be a chill effect in relation to the exercise of its public functions in that case.
Because the amount may be greater.
Yeah, but here it's being said against you that actually the CMA's funding arrangements are such that one can't identify a significant potential chill effect.
My lord, that's true, and I'll come directly to chilling effect in due course. But I don't seek to rely upon this as directly binding or as it were, excluding that, possible consideration. But I do rely upon it for the emphasis that it places on the thoroughgoing importance of the capacity in which the public authority acts, recognising, of course, the point that my lord has put to me. The third proposition is that the rationale for the Booth line has been considered and analysed in the case law. It's based on a variety of public interests, including in particular the virtue of promoting the public interest in contexts where regulators are reasonably performing the functions Parliament has ascribed to them. There might be thought to be three elements to that, again, which I flagged yesterday, but is worth at least taking on the chin at this stage. The first of them is about, to pick up the language of Lord Newburger in Perin Panathan, is about the legal policy and justice of recognising that public authorities are doing useful things in the public interest and are not to be equated with private litigants acting in their own self-interest. So there's an element of real importance built into the rationale relating to the capacity in which the public authority is acting in contrast to private litigants. Secondly, these rationale include the desirability of encouraging public authorities to make and stand by honest, reasonable and apparently sound administrative decisions made in the public interest without fear of exposure to undue financial prejudice. That's a direct quotation from Lord Bingham's third proposition, as I'm sure you will have recognised. And it was that proposition and that feature which the Court of Appeal in BT and Ofcom at paragraph 67 took into account, and in relation to which they said there is no doubt that that proposition resonates and must be taken to be of some importance in the situation that faces this court, that is, in the competition arena in the Court of Appeal in BT and Ofcom. That encouragement is, I respectfully submit, a legitimate feature acknowledged in the cases. I'm not going to go back over the discussion I had with Lord Stevens yesterday about whether or not public authorities should need any form of encouragement of that kind. My submission is that this element of it, this encouragement element of it, deals with the insidious impact on the public interest rather than requiring some demonstrable drop in enforcement or decision-making. It goes, in effect, to the risk that the sort of public interest considerations that should be guiding the decision-making of authorities of this kind might be skewed by introducing cost, risk-averse features. And the third element is the more direct one, the financial consequences potentially leading to a chilling effect. And the first point perhaps to note in relation to that is that all of the cases that have considered this issue have put that on the basis of potential. The fact of a risk of that kind is undesirable given the importance of the public interest functions being performed. And of course here, the CMA is the body charged by Parliament with the responsibility of making markets work well, fairly and in accordance with law, in the public interest.
I haven't understood the difference between this point and the previous one. Aren't they just different ways of saying the same thing?
There may be slightly different ways of saying the same thing, but I thought it right to split them out because the encouragement bit is perhaps more of an insidious risk, an inherent risk that it would be very difficult to prove I think all of this is very difficult to prove, perhaps, but my lord, I think I accepted yesterday.
Well, encouraging and not deterring.
Are similar.
Well, I think the skewing of the factors, I was just thinking about that in the context of the Ofcom reviews, because a sectoral regulator like Ofcom or the water regulator or Ofgem, a lot of their job is to open up the market to the disadvantage of the incumbent and the advantage of smaller actual potential market entrants. And I can quite see that one would not want Ofcom to be influenced by the fact that the incumbent has got more deeper pockets to challenge the conclusions of a market review as compared to smaller competitors in the market. And one wouldn't want them to be influenced by saying, well, we better be a bit kinder to BT because they're more likely to challenge us if we don't take a conservative approach to opening up the market.
Yes.
Whereas the smaller competitors are less likely to challenge because one wouldn't want to encourage them to take that.
I feel a but coming.
Well, yes, so I'm just thinking of whether this is the difference between your third and second.
Potentially,
that it's,
I suppose.
That in the dispute resolution cases and really in market review cases, there is a balance being struck by the regulator between different market participants, in particular, as I say, the large incumbent as opposed to smaller players in the market. And one wouldn't want to skew the factors taken into account.
My lady, yes, I'm not sure I would necessarily confine that thinking, with which I respectfully entirely agree, to that context. That's why I said, rather impertinently, I think there may be a but coming, because you can see that the distinctions then become very fine in relation to what might be called pure enforcement action. One's using that as the contrast, as it were. In relation to that situation, a regulator still has decisions to make. Am I really going to go after this person? Am I really going to go after them? Is the game worth the candle? And by and large, that's the same features, the same purity of public interest consideration, unaffected by cost risk, should apply in relation to those sorts of decisions, recognising that they are, to some extent, necessarily discretionary. You have to pick your battles. You have to choose who to go against. You have to choose when it's the most effective way of doing it, and you don't really want that being impinged on in this way. Of course, none of this goes too far, because they are public authorities. One can expect them to hold to the purity to some extent anyway, but the risks are there, I respectfully submit, across that sphere.
In this enforcement proceeding, we've been told that there was quite an extensive regulatory action phase where there was an investigation by the CMA, and that the costs wouldn't cover the costs of that. What happens in a market review? Do you have the same pre-examination with no costs, and then you go into the review?
Yes.
Right.
Same essential structure, I think. I'm getting nods from all over, including from Lady Rose, which is helpful. Yeah, so same features. Just focusing still on that third element of it, if there is a distinction between 2 and 3, as it were, but focusing on that, I mean, it's a point, again, I've made already, but the risk of chilling effects, and that's what you're aiming at, is not, we respectfully submit, or is very difficult to be treated as a point that can in some way be proved by empirical evidence. And that may well explain why the language that the courts have used is cast a bit more carefully than that. So you have the word might being used in paragraph 40 of Baxendale Walker, 1180, might have a chilling effect on the exercise of regulatory obligations to the public disadvantage. You remember the way in which Lord Bingham put the third proposition. You have additional citations to the same effect. I think one of them from RBS Backhall in our case at paragraph 86B, B for Bertie and D for Daddy. Don't need to turn them up now, but they're all cast in that rather cautious language for understandable reasons, I respectfully submit.
Well, you're not going to get evidence that public authority has been pulled back, as it were, probably in a particular case, but you have to consider the likelihood in the particular context, don't you? And you consider what its budget is, how it operates, what the nature of the decisions is.
Well, my Lord, perhaps, yes, perhaps in some contexts, although it is notable that, as I said earlier, in none of the cases which are felt able to reach that conclusion, including, I think, properly analysed, the Court of Appeal's decision in BT and Ofcom, in none of the cases, apart from BT and Ofcom, was there any evidence at all of that description. And yet the court felt able to make the judgment call. So, of course, yes, I accept it's to be considered in context, but it has not been felt necessary as a precondition to the reaching of that conclusion that evidence be produced. And there are difficulties with that. As I say, I don't exclude the possibility that context, budgets, last year's accounts and so on, which I'll come to, might play.
It may be, Sir James, that in some cases it's quite easy, by looking at the nature of the public authority and understanding its budget, to infer readily that it could not support expensive litigation. I don't think one can justify a principle by saying, well, it applies across the board, regardless of the risk.
My Lord, no, and I'm not.
I don't think you are. No. But what you are saying is, well, the courts haven't relied on, other than in BT and Ofcom, on evidence, and that appears to be the case. But what I'm suggesting to you, it might be because the nature of the bodies they were dealing with, it was self-evident that there was a risk.
That's possible, although that proposition in itself may be difficult. Because if one thinks of the two classic contexts that the courts have been considering in the main cases we've been looking at, they have been the police and the Solicitors Regulatory Authority. And certainly in relation to the police, they no doubt have ring-fenced budgets and lots of money that they can spend on different things. Not sure how that is different in principle from a regulator with a limited budget granted by central government or local authorities to the same effect.
It isn't. But I mean, the police and local authorities have very wide-ranging public duties, and are. It's well known that they're budgetarily constrained in fulfilling everything that they need to do. Is that really true of the CMA, which has an extremely focused public duty, and the financing arrangements of which we have direct evidence?
Well, my Lord, no. Of course, the functions are much, much broader in the context of the police and local authorities. Of course, that's right. But the question is whether or not one can say that their budgets were, as it were, their budgets that are referable to taking the sort of enforcement action which the courts considered, are the budgets available for those purposes so constrained as to lead to the need for evidence. And I respectfully submit that it isn't at all self-evident that they are different in that respect, although of course their functions are broader.
We have the great advantage of actually having some evidence in this case. Are you suggesting that there is a potential for financial chilling?
Yes, I am.
Yeah.
I am. Perhaps I better come to that directly.
Well,
it is.
Take it in your order.
No, it was the point I was on to next. It is said that there is no risk here in the case of the CMA, and we respectfully and strongly disagree with that proposition. You're aware that the cost risk in these cases can be highly significant, as illustrated by the numbers that we've been talking about here. I have to say I'm not much comforted on behalf of the CMA by the fact that in this case some of those numbers were taken down as having been excessive. The point is a general one. Fines that the CMA receives go under the statutory regime to the consolidated fund. That's section 38 sub 9 of the Competition Act, page 1468. They are public money, as is the funding that the government decides should be available to the CMA. Using penalties to offset litigation costs is simply, by arrangement with the Treasury, an accounting mechanism. And it's an accounting mechanism that the Treasury has simply indicated pro tem that it is content with. As I understand it in relation to the facts, at least in relation to the CMA, there was an arrangement introduced in April 2015 that 50% of the fines could be available for that purpose. That lasted for 3 years, till 2018, as I understand it, and now 100% of the fines can be available for that purpose. But the key point is that it is simply an administrative arrangement.
Well, presumably its purpose is to encourage them to go after people and not to, when they think it appropriate, and not to hold back.
Well, my lord, its purpose is no doubt to avoid money spinning round that doesn't need to spin round. I'm sure part of it is the purpose that you identify. But it is purely an administrative arrangement.
Well, but it is a mechanism that encourages the CMA to go against large undertakings, given that the fine is calculated as a starting point, at least as a percentage of the undertaking's turnover. So if they go against big companies and fine them, they can impose a much higher penalty than if they go against a smaller company. Is that still right?
Well, my lord, I'll be told whether that's right as a matter of fact or not, but it is still simply an administrative arrangement with the Treasury. And the Treasury could turn around tomorrow and say, we're not happy with this after all. We'd like all the money to go, as the statute appears to require, into the consolidated fund. And where would anyone be, as it were? It would just have to come by way of additional funding from the Treasury, cap in hand, each year in the usual way. They'd have to bid for it, and all of that would simply revert. So there is a real problem, I respectfully submit, building an important point, if you consider it to be an important point purely on an administrative arrangement that could be altered. And the fact that it could be altered rather illustrates the point I made earlier on, which is that this is just a convenient mechanism for stopping the money swinging around in a circle. Difficult to see how...
Well, I just wonder whether that's correct, though. I mean, you assert that it's an arrangement to stop the money going round in circles, but we haven't got any documents at all. The
same could be said about all the money that goes to the CMA.
Of course.
But it's only set off against the costs, so that's presumably a particular reason for that.
Yes, but it all comes, ultimately, it all comes from public money. And just to take my Lord Stephen's point, no one has pointed to any legal provision that requires that setup.
No, but there's no legal provision that requires the government to pay a set sum to this court to keep this court in operation. I mean, it ultimately is a matter of an administrative arrangement and negotiation with the Ministry of Justice and the Treasury.
Exactly so. My Lord, I entirely agree. That's indeed the point I'm making. So there's no great significance in the use of this particular mechanism for as long as the Treasury is content to let it last.
But is it not an indicator that under current circumstances at least, the powers that hold the purse strings are willing to fund the CMA in a relatively expansive way by making available the 100% of the fines for offset against their costs?
Well, that also is true. They are prepared to do that for the time being, and if that arrangement didn't exist, There would be other considerations that would have to be taken into account by central government as to the level of funding of the CMA. Yes. And they might be generous and they might be less generous.
But don't we have to measure things as they are now?
Well, my Lord, I'm not sure you necessarily do. If the invitation to you is to say you can be entirely satisfied that there is no chilling effect, no possibility of a chilling effect on the CMA because of a snapshot of how the arrangements are set up and what the level of fines might be in a particular year, then that is extremely problematic, I respectfully submit. It's problematic, firstly, because the decision makers are well aware anyway that they are dealing through whatever detailed mechanisms, they are dealing with public money, which ultimately depends upon funding from central government, and it's natural that they should be concerned about the risk of cost in those circumstances. Secondly, the amount of the fines and all the costs, and there's an obvious correlation between the two, may well be variable. The fines imposed in any given year are likely to represent the result of quite a lot of pipeline work that's taken place over a number of years, and the ratio of cost to fines depends on how successful the CMA is in litigation, how good it is at making the discretionary judgment calls that we've been discussing. And true it is that the accounts to which my learned friend Mr. Brearley took you referred to fines over a particular period of 50-odd million, and then he rather bandied about the current year of 400 in the current year, he said with a flourish without taking you to anything. But the 400, to take that as an example, is not income, and it's not income that's been received, not least because his clients and others have appealed. And if you appeal, you don't have to pay pending the appeal being resolved. And the appeal at least raises some prospect of the appellant being successful. And of course, if that is so, in relation to the 400, which is mostly made up, as I understand it, by those cases on appeal, if that is so, not merely has the income not been received, but if the appeal is successful or successful in part, not merely will the fine go down, but the costs will go up. And so if one is dealing with those examples, that 400 example, which the majority of which is accounted for by, as I understand it, those cases, those decisions which are on appeal. Is that one cartel infringement? Yeah, I think it's hydrocortisone and lyrothemine, if that's the right way of pronouncing it. But those are on appeal, and they have a large number of appellants. 5 and 3 appellants respectively, in which the costs of the appeal are likely to run into millions, tens of millions. Assume the CMA loses those appeals, doesn't get the 400 million, or whatever proportion of it is comprised in those appeals, it will face an enormous cost bill, and it will need to account to the Treasury, to central government, for those costs, for that loss of the notional fines that might otherwise have been imposed, and all of that. None of that is taken away by the existence of this arrangement or its intricacies. The fact of the matter is they're funded by central government. They're dealing with public money, and they are aware of the risks that that entails for obvious reasons. It's thoroughly important for their continued operations.
You can't just ignore the other side of the point, though, because if you're a company that is dragged over the coals by the public authority, and you have to go on appeal, and you are ultimately vindicated, and you've had to incur large amounts of costs, there's on any view an unfairness if you just have to whistle for it at the end of the day.
My Lord, yes, I don't think anyone's denying the possibility of some form of effect of that kind in relation to appellants, but that is a position which is acknowledged and accepted in striking the balance of public interest in the Booth line of cases, because all of those points are equally relevant and applicable to all of the people there. There's a degree of unfairness to those who are not getting their costs having succeeded. But ultimately, this is a balance. and the balance has been struck in favour of the public authority, it appears in principle precisely for the reasons that were given by the Supreme Court in FSA and Sinola and by Lord Sumption in the Gallagher case, because there is a difference between the public authority acting in the public interest and the encouragement and the risks associated with that and other people.
Is there also a factor that the way that the competition enforcement is structured in this country, which is not necessarily the same in other countries, means that the decision imposing the £400 million fines is taken by a body which is not Article 6 compliant, and it's the appeal that entitles the addressee of the decision to have an independent and impartial tribunal assessing the validity of that penalty, rather than other countries in which the equivalent of the CMA brings a prosecution, as it were, before an Article 6 compliant tribunal. I know you referred yesterday to the review body that's set up, I think, within the CMA before a decision is taken, but I still think that it's the tribunal which is the compliant body for all the purposes of the convention.
My lady, yes, I don't think, I mean, I'm sure it's right, and it's a position with which you're very familiar in public law terms, because you have an equivalent situation under the Bryan and the United Kingdom line of authority to do with all sorts of different contexts in which the same principle applies. I think the answer of principle that I give to my lady's question is that the fact that it is true in a legal sense that the tribunal provides the independent and impartial tribunal that Article 6 would require, and you don't get that from the internal processes, although they can of course be taken into account under that line of authority. How fair they are may affect precisely how the tribunal goes about doing its business. There is nothing in the jurisprudence under Article 6 that would set its face against the operation of a Booth-type principle. There's nothing in the context of Article 6 to suggest that pursuant to its to the various margins that would no doubt be afforded to the state, it couldn't set up the various regimes for determining disputes that are covered by the Booth line of authority, including the competition arena, in a manner that gives precedence, as it were, or favouritism, if you prefer that, to the public authority, with some commensurate and necessary degree of unfairness or less fair treatment to the person who's won and doesn't get their costs. That's a concomitant of the principle. And again, the same points that I've just made would obviously have been relevant, and I would have been making the submission had I been arguing the case in relation to the SRA and or the previous iteration of the Solicitor's Regulatory Authority and indeed the police in the forfeiture cases. But just to finish the risks, and just so that this isn't lost, as my lady will be very well aware, I'm sure the members of the court, the other members of the court also, there are, it won't surprise you to hear, all sorts of big fights on the horizon, which illustrates the don't take a snapshot approach and illustrates also the size and scale of the risk. The big fights on the horizon post-Brexit, in which the CMA has taken over responsibility for cases that would previously have fallen within the competence of the European Commission, and that may very well require a series of difficult discretionary judgment calls about enforcement litigation and other regulatory action against those who are properly global big beasts. And they will inevitably break new ground, and there will be difficult decisions to be made around how that is to be done, all of which is grist to my mill, I respectfully submit. So the short points in relation to all of that are, firstly, that in the context of such action and potentially repeated action going forward, there is a plain risk of chilling effects inherent in the decision-making and the structures that we are dealing with. But secondly, and perhaps as importantly, one cannot possibly say with confidence, or with any degree of confidence, there is no chilling effect. You certainly can't say that on the basis of a single snapshot of a particular year's accounts accompanied by an assertion which turns out to be deeply flawed and inaccurate about the current year fine position. If the risk of chilling is not inherent and is a matter on which the court would be assisted by evidence of whatever description, then the matter would need to be considered on that basis. And you will recall that the CAT in our case, it was paragraph 46 or 47 that you looked at yesterday, didn't decide anything in relation to the chilling effect. And if it's not inherent, if that might be relevant, particularly given the broader time frame which I'm inviting you to view this issue through, you would have to remit to enable at the very least that to be considered. So that's the third proposition. The fourth is a much shorter one, which is that the principle is of general application within the parameters of its operation. The courts have approached the issue by asking whether the principled approach in one case should apply on the basis of its underpinning to the different contexts that have come before the courts, and thus whether a principle of more general application is in play, or whether or not this is susceptible to the sort of fine cutting that you saw being deployed by Mr. Keith on behalf of the claimant in Perin Panathan and by Mr. Beard in the BT and Ofcom case. And the courts have eschewed that approach. They have said, no, we're not having any of that. There is a general principle in play here. That perhaps is exemplified by the passage from Lord Newburger's judgment at paragraph 63 of Perin Panathan that I took you to. But it's been repeatedly tested, and indeed that's the common law way, as Lord Justice Arnold pointed out in his judgment in the present case. Of course, it doesn't set out, this position that they've ended up with, the courts have ended up with, doesn't set out a universal or a hard-edged one-size-fits-all rule. The principle is presumptively applied when it operates, unless the context and other factors produce good reason for doing something different. But the generality of it has been acknowledged. The principle is, as the Court of Appeal put it at paragraph 66 of BT and Ofcom, expressed in, and this is what the court said at 66, in very general terms that is capable of direct, if analogous, application to the context that were there being considered, the competition arena. And the courts, in the same paragraph, the Court of Appeal acknowledged that the courts in previous cases had contemplated, as they put it, that the principles that they were enunciating would be of significance in application in other areas. And the key feature that has been identified in the case law as creating that principled position, the key feature is the one that I've repeatedly emphasised from the case law, that the regulator is acting, again to go back to BT and Ofcom para 72, solely in pursuit of their public duty and in the public interest in carrying out regulatory functions. That was the point made at 72 of BT and Ofcom, and then reiterated in pretty much the same terms at 74 and again at 83.
You say it's not being put forward as a universal hard-edged rule, but might it not be said that paragraph 79 of the Court of Appeal's judgment in this case is actually a universal and hard-edged rule, because they lay down a rule that costs should not follow the event against a public authority, subject to very specific and very narrow exceptions.
Well, my Lord, my sixth proposition is going to be that they aren't necessarily that narrow, and that good reason is a broad church and can accommodate the taking into account by the tribunal of all the relevant circumstances. So what I meant by it isn't a universal and hard-edged rule. Of course, there is a principle which can be described as hard-edged, which is that you start in the context of a public authority operating in the way I've described with a presumption, that is a principle or a rule, certainly, but it is qualified. And to some extent, it goes all the way back to the debate we were having about Booth and whether or not it was only where they act unreasonably. That was the proposition that was rejected, as you will recall. And then we went to Lord Justice May, who said for good reason. And the debate I had yesterday with Lord Stevens about whether that was consistent with the third proposition that Lord Bingham set out. But ultimately, that, in the subsequent case law, has been where the courts have landed. So I only mean not universal and hard-edged in that sense, as it were. Of course, I make the positive submission that it applies generally in the sphere of its operation. That's the thrust of that fourth proposition. The fifth proposition is this, which is that it is...
sorry, I thought we got to 6 now, but maybe I've counted one of your propositions twice or something.
I'm with Sir James on 5.
Oh, right, okay.
The fourth proposition is general.
6.
They do a spin. The first one was distinction between a context in which there was a CFE and not. The second one was the importance of recognising that the body is a regulator.
Yes.
The third one is the rationale have been analysed in the case law.
Yep. Yes.
The fourth was it's of general application.
So your
Oh, I see.
potential chilling is part of the third one then?
Yes, because that's the core of the rationale.
As part of the third one, and also you're taking off your course of submission.
I see. Well, I counted as a fourth. In fact, you were just, it was a diversion to deal with the risk in the case of the CMA.
Yes, my lord.
We are where we are.
Yes, thank you.
Are we back on numbers track? The numbers track is 5 now, anyway.
Yep.
The proposition is the importance of the fact that a regulator or other public body is acting in performance of the public function is properly reflected in the creation of a presumption / starting point / default position. That's a mechanism for giving proper effect to the weight of the point. I use the word starting point or default position. I think that was coined for the first time by Lord Justice Stanley Burnton in paragraph 40 of the Perrin-Panathan decision, but it was taken forward in BT and indeed in the Court of Appeal's judgment in our case, and for good reason, I respectfully submit. I'm going to get deeply confused because there are 4 sub-points under this one. Shall I call them A, B, C and D? Sub-point A, it is not just any old factor. It's a factor that's been acknowledged from the outset, including by Lord Bingham, as being of real importance, reiterated in BT and Ofcom at paragraph 83 in the final concluding paragraph of the substantive reasoning. And that is because its principled underpinnings recognise the public interest and the importance of the public interest that it serves. So simply characterising it as a relevant factor, a fortiori, concluding that it's an irrelevant factor, but simply characterising it as a relevant factor with all the other straws floating around in the wind would risk it being given insufficient weight or indeed no weight at all. B, that importance, recognising that it isn't just any old factor, is accurately reflected in setting it up as a starting point or a default position or a presumption.
A starting point isn't a presumption. A starting point doesn't presume a consequence. It's just the beginning of a process. And so there's a difference between them.
My lord, I'm taking the principle as including the unless there is good reason not to.
Well, that's a default position.
Yes, but it is closer, I think, to a default position or presumption than
Yes,
a starting point.
Yes.
Yes. Well, my lord, the court...
Starting point, you start one area and then you take into account all the other circumstances and you arrive at an eventual decision.
My lord, I'm entirely prepared to accept the structural force of that. The language has been used by the courts, as you have seen, and my submission is that the effect of the principle, however you describe it, which is no doubt why they put lots of alls in there, the effect of it is as I've described.
Yes. Yes. I mean, in 79, the Court of Appeal equates starting point and default. It's the same thing in their reasoning.
It is, and there is at least a strong flavour of presumption in the unless bit. But is it proper to do it in that way? Is the second sub-point, or the B sub-point? And we respectfully submit it is, because the weight of the point, the weight of the significance of the fact that the regulator is acting in the public interest, is of such importance and has been acknowledged to be of such importance that it displaces the general starting point that is otherwise common and would otherwise apply, namely that costs follow the event. Success in the hands of the claimant or appellant is not merely not sufficient, the default position operates the other way, and that's been the position since Lord Bingham in Booth. Critical to remember that Lord Bingham rejected the proposition in terms that in the open-ended jurisdiction that he was dealing with, costs follow the event was appropriate. And unless the starting point or default position is adopted, there's a problem at the level of principle, because these considerations, this factor, cannot meaningfully be taken into account if the starting point is costs follow the event. Lord Bingham was entirely clear about that, and all subsequent cases likewise. So this is about prioritising by reference to the weight, particularly recognising, as Lord Neuberger did at paragraph 75, that there are often, and here, pretty much two games in town to choose between in terms of the starting point. And the problem at the level of principle is reflected, we respectfully submit, i.e. that you don't end up giving it sufficient weight, that you do allow the alternative presumption or general rule to creep back in. That problem of principle is reflected in practice, and it's borne out by the CAT approach over its case law we submit. I'm not going to take you back to all of the CAT cases that are relevant, but if I can just give you the submissions in relation to those. You saw the potentially more open-ended approach in GISK, paragraphs 56 to 58, tab 21, page 1248. But ultimately, that hasn't been taken forward. Those features have not in truth been taken forward by the CAT. And what has happened in the case law is that that case law, in rejecting as relevant the Booth line of authority, which was the fundamental problem identified in BT and Ofcom and in our Court of Appeal's judgment, they've ended up inevitably hardening their stance into the equivalent of a CPR CFE starting point. And one sees that done in the series of cases which you have in your, at the beginning of the authorities bundles. So in Racecourse, tab 24, page 1301, they interpreted, the CAT interpreted, see paragraph 8 at 1304, they interpreted the GISC case as, quote, reflecting a starting point that a successful applicant ought, subject to all other considerations, to be entitled to be compensated for the costs he's incurred in vindicating his rights. That is CFE. And exactly the same point is made in paragraph 10 on page 1307. In Eden Brown in 2011, tab 20, page 1212, exactly the same. Paragraph 6 at 1216 follows Racecourse, which laid down CFE as a starting point. and concluded in terms that CFE as a starting point applied just as much in the Competition Act 1998 penalty appeals as to appeals against infringement decisions. See paragraph 9, 1218. And by the time you get to pay TV, you saw the quotation in BT and Ofcom Court of Appeal judgment of paragraph 50 of pay TV. By the time you get to pay TV, page 1860, this is seen as the proper and general approach or rule or starting point. Across the cat. And we've referred you in paragraph 81 of our case to the Flynn contention that the cat's approach is, as they put it, quote, a textbook example of the proper application of Lord Bingham's approach. In fact, as we've seen, it's nothing of the kind. Lord Bingham rejected costs follow the event as appropriate. And the cat, principally by not recognising the significance of the Booth line of authority, has got to that place. And in fact, and more directly, the cat itself in Eden Brown directly rejected the proposition for which Flynn contends. See Eden Brown, paragraph 16, page 1221, where the cat said the approach in Booth, as considered and explained by the Court of Appeal in Perrin Panathan, should have no application to an appeal before this tribunal. So we respectfully submit that the cat line of case law is illustrative of the difficulty of not applying the Booth line of authority as creating a starting point, because it opens the door, as it were, to precisely the problem of principle and practice that the cat line of case law exemplifies. And that was, in essence, the conclusion of the Court of Appeal in BT and Ofcom. And the cat's cost ruling in our case, again, far from being a classic example of them operating consistently with the Booth principle, contains exactly the same error or set of errors. They asked, cost ruling is at page 295, they asked if the Competition Act 1998 appeals involved a regulatory decision, quote, sufficiently similar to that considered by the Court of Appeal in BT and Ofcom. But that was the wrong question. And it was the wrong question, as was evident from the Court of Appeal's judgment, because the Court of Appeal had deliberately reviewed the range of contexts in which the Booth line had been applied to try and identify the connecting principle.
But if one had rephrased that, the question that you criticise, and said, if the cat had asked itself, is there a good reason in these infringement decision appeals to depart from the Booth starting point presumption, whatever, of no order as to costs, would that still have been subject to criticism if they'd phrased it like that and said, well, looking at this kind of case as compared with the BT Ofcom kind of case, we see they are different, and therefore we say that there is a good reason in this category of cases to depart from that? Or do you say that good reasons are only individualistic?
My lady, I say that good reasons have to be individualistic within the sphere within which the principle operates. That was the essential reasoning of the Court of Appeal in BT and Ofcom. And I do respectfully submit it would be an error to say, well, we can introduce through good reason some sort of distinction of that kind. And
so you don't think that there can be good reasons why a particular class of case or a particular jurisdiction should depart from the booth.
Well, I don't necessarily exclude that as a possibility in its entirety, but you can't really do it through the good reason approach, I respectfully submit. And what you have to do is to recognise and properly analyse the nature, the underpinning and all the rest of it of the booth line of authority, work out whether it, as a general principle, applies within the sphere of its operation in your context, and if it does, you're then down that road. And the down the road does require good reason to be individual. That, I submit, is the right approach. That was the essence of the reasoning of the Court of Appeal in BT and Ofcom, and indeed in our case.
Surely in Ofcom, the Court of Appeal was saying that they should consider whether the particular kind of appeal is one in which the booth approach is appropriate or not.
Well, my lord, that rather goes back to why the thing was remitted.
Well, partly it does, but it also goes back to what the criticism made was.
Yes, and the court's reasoning was that the principle was nevertheless at least prima facie applicable, and they needed to come at it on that basis. They couldn't come at it on the basis that it was irrelevant. And that was the fundamental vice that you identified in the Court of Appeal in BT and Ofcom, and it's the same vice, because they keep, as it were, going back to us and saying, well, here are a variety of reasons why it doesn't apply at all.
Well, do you say that the Court of Appeal was wrong to send the matter back in BT and Ofcom? Because really, I mean, that seems to be the conclusion the Court of Appeal in this case has come to, because if it's a general principle that applies across the board, then there's no point sending it back. That's what the Court of Appeal said here. So well, really, they were saying we're wrong to do so in the...
Yes, I don't want to do the Court of Appeal here a disservice. I mean, they kind of said that, but they also had the benefit of a set of arguments, almost none of which are resurrected in this court, as to why the particular regimes, the regime that they were considering in this case was different, or were different. And they concluded that they could reach a view on those arguments, and they did.
No, but the reason the Court of Appeal sent it back in BT wasn't primarily because they couldn't reach a view, but they didn't think that they were the right people to reach the view.
Yes, my lord.
They thought it ought to be a cat. So I don't know whether one of your propositions is going to address that question.
Yes, my lord.
As to who should make the decision.
Yes, my lord, the reason that the Court of Appeal in our case decided that they were in a position not to take that step, as I understand it, was because they felt they'd had full enough arguments on those points to be able to form a view on the matter themselves. And they plainly did consider whether or not the right course was to remit it. But it isn't a principle of universal application that an appellate court always has to remit back, even if it's dealing with the context of a specialist tribunal as we are here. So the reasoning of the Court of Appeal, as I understand it in this case, was very much based on the idea that there had been full argument about whether or not these particular appeals carried with them particular things that took them outside the reach and scope of the principle. But there is, of course, that is, of course, a judgment call. And I mean, in terms of the theoretical outcome, I'll come to it at the end, but in terms of the theoretical outcomes to this appeal, you can either uphold the appeal, as it were, and agree with the Court of Appeal, or query, remit. And on various ways in which this appeal could be disposed of, that might be the right answer, if you go down a particular set of routes, as it were. I think, in fairness to the Court of Appeal here, they only did it because they felt they had all the arguments, all the material available to them, all the arguments for distinguishing it and saying the principle shouldn't apply, of the kind, analysing it in the manner in which my lady was putting to me, and they concluded that they could make the decision.
So where we get to, presumably you would accept that when the CAT is applying Rule 104 in a damages claim between individuals or between undertakings, then this Booth principle has no application and it's fine for cost to follow the event in that situation. But you say that whenever the CAT is dealing with an appeal against a public body, then the principle applies there's a presumption of no order as to costs unless there is, in this individual case, a good reason why it shouldn't apply. Is that where we get to?
It is. And that's pretty much where the Court of Appeal got to. I said there was an A, B, C and D. This is C.
Yes, I'm up to 3.
C is that there is real merit in ensuring consistency and clarity of approach. At least some of us all agree in stentorian terms that a starting point is a jolly good idea. And that is a feature correctly highlighted in the case law, especially perhaps by Lord Newberger in Perin Panathan, paras 59 and 64. And indeed also, to the same effect, the citation by the Court of Appeal in BT and Ofcom from the number, which I drew attention to at paragraph 81 on page 1210. And can I also just give you, if it's not loading reference upon reference for unnecessary purpose, given the authority of Lord Newberger, the Ofcom case helpfully draws attention to one other reference to the same effect, this time from an Ofcom, from a merger action group case. And you have the relevant citation at paragraph 17 of Ofcom's case. And the courts
in Ofcom's written case in these proceedings.
Ofcom's written case in these proceedings. I'm so sorry, my lady. I'll give you a page number to make it easier. 223 in the electronic. And as the various cases there point out, including in particular the number, which I took you to, was cited by the Court of Appeal, the starting point recognises, having a starting point recognises that you can't sensibly rest with the proposition that the regulator's status and the question of who's won are both starting points, as it were, or both relevant considerations on which the tribunal may place such weight as it thinks fit on a case-by-case basis, because you just end up with incoherence. No idea how to weight the factors. The final sub-point under this, the fifth proposition, point D, is that we do not accept that this recognition of the significance of the regulator point as a starting point is truly any departure from the thinking of Lord Bingham in Booth, let alone some radical or impermissible departure that the subsequent cases have taken. Everyone accepts that it's a relevant factor. Lord Bingham recognised that it was an important factor. He evidently considered that it was a feature of such weight as to displace the costs follow the event ordinary general approach otherwise. So it might be thought that if Lord Bingham was asked to choose, it's entirely clear what choice he would make between CFE on the one hand and regulator on the other hand as starting points in a context such as this. And once that is recognised, the approach taken in the later cases is simply logical and necessary as a development of that thinking to ensure, by giving it that characteristic, that the principle carries the weight and is not washed away by the encroachment of a CFE approach, which it would be. See the CAT jurisprudence. And it might be added that none of the later courts appear to have thought that what they were doing was anything other than faithfully applying Lord Bingham's thinking, whether or not they were technically applying it simpliciter or developing or refining its logic. Perhaps the final point to make under this head is that one can have a debate, perhaps, around whether or not it should be a starting point or treated as a starting point or simply as a factor in the debate. And the other side seek to make a virtue of it being a factor only under the Lord Bingham analysis. So they say, we say that's wrong, but that submission itself recognises that it is a factor. The one thing that cannot be done on the common position of all the parties before the court is to dismiss this point, this factor, as irrelevant. We say it's the correct starting point. That's the analysis in the later case law. That's entirely consistent with Lord Bingham. But even if you don't accept that, it is still, on everyone's case, a relevant factor acknowledged to be of real importance. So it's wrong in principle, as the Court of Appeal found in BT and Ofcom, simply to reject that line as irrelevant. The sixth proposition is this: although it operates as a starting point and default position, or default position, it is only that. There may be good reason to displace it, and that allows for other matters to bear on the just award in particular circumstances. Note at the outset in relation to this point that the principle considered in Booth and submitted for by the local authority, which was rejected, was that public bodies can never be liable, I underline never, can never be liable absent unreasonable conduct or bad faith. That was a submission that was made. That is not our case. And for that reason, it's wrong to characterise the Court of Appeal here as having bestowed in some shape or form a costs immunity on the CMA. The case law indicates, and we emphasise non-exhaustively, but it emphasises or indicates two particular aspects that might do so. The first is the conduct of the regulator, including bad faith or unreasonable conduct. They're regularly identified as sufficient to displace the starting point.
Well, that isn't a different factor from the... I mean, that's the factor that everybody accepts is sufficient to displace.
Yes.
The question is what other factors there are.
Yes, it is, and there's no question here about anyone having acted unreasonably. That, I mean, on the findings of fact that you have below.
Is that unreasonableness in terms of the conduct of the litigation, or could it also encompass the way the infringement investigation process was conducted?
I'm not sure there's any clear answer to that on the authorities. The concept is introduced into the case law as open-ended, and therefore I'm not sure I would shut out the possibility.
It would be very strange if it were shut out. I mean, if the competition authority badly mishandled the investigation and reached a view which was objectively unreasonable, then that would be a perfectly good reason for disapplying the default position, I would have thought.
Oh, well, yes. I mean, I'm certainly not seeking on the basis of any principle or authority to confine it against that. I mean, you've seen the way in which this decision panned out and the bits that were found for us and the bits that were found against us, but no one has suggested, I think, or thought to suggest that there was any finding of unreasonableness. Indeed, quite the contrary. Paragraph 49 of the CAT's cost decision finds in terms that we weren't acting, hadn't acted unreasonably. And the second is financial prejudice. to the particular complainant. And again, you've had various discussions with counsel at the bar about how that might operate. The only thing to remind you about in relation to that and to recommend to the court in relation to that feature is paragraph 41, which I took you to yesterday, I think, is paragraph 41 in Lord Justice Stanley Burnton's judgment in Perrin Panathan, where do you remember he relied on Mr. Justice Toulson in Nestling and considered what was meant by financial prejudice in this sort of context for the purpose of this principle. Other good reason, but again, there hasn't been much exploration in the case law as to precisely what that would entail. We've had a discussion about that as to whether it could be individual when the principle applies, and I respectfully submit that it should be. But there are, or there is no doubt, plenty of scope for argument around whether or not it should or shouldn't apply, having regard to particular sets of circumstances or facts. I'm not sure the court is in any position to seek to define or exhaustively describe what that concept might involve. We know that that chimes with, and we'd have to take account of, the rules that CAT has set up, which say take account of all the circumstances. So I'm not seeking overly to confine that. But it does have to be good reason, because that is reflective of the weight of the starting point. And all of this, we submit, demonstrates at least that for present purposes, perhaps this is the punchline of this point, that the principle is not overbroad or overly rigid. It does contain sufficient flexibility within it, both to recognise the importance of the public interest in regulators acting without fear or favour, to summarise, and that there may be circumstances in which that should properly be displaced. That is a proper and balanced principle.
But as I understand it, you don't allow there can be a category of case where it can be displaced.
My Lord, building on the logic of the Court of Appeal in BT and Ofcom, we do respectfully submit that it should apply when the core elements of the principle that I've identified and sought to extract from the case law themselves apply. Otherwise, as Lord Neuberger pointed out, you risk having incoherence and inconsistency.
Well, I'm not sure that was the logic in BT and Ofcom. I thought the Court of Appeal was saying there that there may be a particular kind of appeal in the CAT where that isn't the appropriate default position, and that's something the CAT should consider.
Well, my Lord, if that's what you decided, then...
Well, I agree that there are different points, but I was looking at paragraph 72, which was one that you emphasised, yes, I think.
As the relevant questions that needed to be asked, and they hadn't been asked in that case.
That's right, but that is not consistent with what I understand your position to be, which is that there's a general rule across the board that where there's a public authority concerned, you start with no order as to costs, unless on the facts of that case there's some good reason to depart from it, such as financial prejudice or some other unspecified additional reason.
Well, my Lord, I mean, the question, I'm not seeking to say that the question that you'd identified in paragraph 72 is not the right question, but when having that debate, if they were going to have that debate, which they didn't in the end because it was settled, there would have been argument as to the nature and reach of the principle, the nature and scope of the principle, and whether or not there were particular features that could impinge on it. And frankly, if I'd been arguing it, I'd have been making the same submission before the CAT on the remittal, which is that the principle should operate within the four corners of its operation, depending upon...
But what the real issue on this appeal is all about, as I see it, is not that it can't be appropriate. Obviously, it is to take account of the possibility of a chilling effect in any situation. But it is the question, is one to assume, as it were, that there's inherently likely to be such a chilling effect which leads you to start with a default position? Or do you analyse the risk in the particular context to decide whether that is of sufficient concern to justify making it as a default position in that category of case.
Well, I've addressed you on chilling effect and made the submissions that I've made about chilling effect. My submission, again, I've made this point, my submission is that if and to the extent that there were going to be said to be features of this type of appeal to CAT, those were issues that were considered at some length. As I reminded myself last night, having gone back to the reply submissions I made before the Court of Appeal, they were considered at some length below by the Court of Appeal, and it was that feature, in effect, proceeding on the premise that there were category arguments to be had, perhaps without prejudice to our primary position that it should operate within the four corners of the principle. They did consider whether these sorts of appeals should be treated as a special case, and they decided not. That's why they didn't feel it necessary to remit. So the answer can be twofold. The first answer is, in principle, and this is a proper principle to be derived, or a proper approach to be derived from the run of cases, it should operate within the four corners of its operation because the rationale are the same, and otherwise you end up with incoherence. Of course, there may be differences on the facts to do with chilling effect. But two, even if there is scope for, whether through good reason or through as it were, an a priori analysis of whether or not the particular context should lead to the application of the principle or not. That has been done by the Court of Appeal. Well,
I can't remember. Is there any section of their judgment in which they address the question of whether there's a real risk or real cause for concern in this kind of case about the CMA will not take proper decisions if it might get costs orders against it?
I thought at paragraph 100 they said that they weren't persuaded that there was a chill effect.
Yes, they said that they said they wouldn't regard it as self-evident.
No.
But insofar as it has potential to exist, and the risk of it, it's already accommodated within the principles developed by the cases in this court.
I don't understand what that means.
I think it means...
No, it just means that if there is some, well, then it'll be... But what if I mean, what if there isn't any likelihood of chilling effect? Then it isn't accommodated within the principles.
Well, there's nothing in paragraph 79 which says that subject to the establishment of a chilling effect, that these principles apply. Like Lord Leggett, I don't really see what the court means when they say it's accommodated within the principles.
My Lord, I think they were taking the position, certainly the submission before them, was that the risk of chilling effect in all of the senses that I identified earlier was inherent in the context. And that was the approach taken in all of the cases apart from BT and Ofcom, which was the only one that produced evidence.
On the basis it's a public body, it's paid for by the public purse, everyone's strapped for cash all the time.
All of that.
And therefore there may be a chilling effect.
All of that. There were, in none of the other contexts where the principle has been developed have they called for evidence, have they said there was evidence. And it's evident that the Court of Appeal took that view. Indeed, I think when we had an argument about remittal below, it was very much put on that basis, and I will put it to you again in due course, which is that you either conclude that that works, which appears to have been the approach of the Court of Appeal, however infelicitously expressed in paragraph 100, it's either inherent and not necessary and not empirically provable, and you can take it as existing in this context, or if you conclude that isn't good enough and that it is a subject of evaluation / evidence / consideration, that has never happened. Hasn't happened, wasn't done by the CAT in this case. They specifically didn't do it in their cost ruling, 46, 47 of the cost ruling, and nor, I may say, did the Court of Appeal.
Just going back to the question whether one could adopt a category-based approach, depending upon whether you think in a particular category there is a chill effect or significant potential chill effect, as opposed to other categories where it may not be. I mean, isn't there a lot to be said for adopting a category-based approach, precisely for the reasons given by Lord Neuberger in Peripanathan about the reason why it's desirable to have a presumptive default rule, so that at least the parties know in broad terms what is likely to happen if they litigate about the costs?
My Lord, I think the answer to that is yes, I agree, but with a note of caution about what you would need to get to the place of working out whether there is chilling effect or not. So yes, in principle, if you were able to conclude with real confidence there is no risk of chilling effect at all, then I obviously have to accept that large swathes of, if not the entirety of the underpinning of this goes, subject to the three ways in which I put broadly chilling effect. And so I see the force of that, and it would be supported.
I think part of the criticism of the Court of Appeal is that they didn't allow for that exercise to be undertaken. I mean, we've looked at paragraph 79 and 100. I mean, so far as I can see, what that boils down to is you assume, if you've got a regulator before you, you assume that you're into the regime in paragraph 79 without any prior examination. Is this a category of case where it's sensible to apply that regime or not?
Well, my Lord, I think they were, as I say, I think they were taking that, and it may be my fault for having led them into error. I've often done that. But they were taking it, as I understand it, as inherent in almost all contexts, if not all contexts, where regulators of this kind were involved. They were.
I think that's putting back to me what I was putting to you. Yes, they haven't allowed for an examination whether you can have subcategories. It's, if you're a regulator, it's assumed that this is the appropriate regime.
My Lord, I think that's fair, and I respectfully submit that is fair enough as well.
All right. Yes, of course.
that's fair and
yes.
Fair enough.
And they also assume that if there is a chilling effect, that's a kind of trump card, really, that if there is a potential chilling effect, then there aren't other factors that might nonetheless make it inappropriate in this category of appeals for there to be a presumption of no order as to costs.
Well, my lady, I'm not sure I would accept that, because there was, as I say, it goes back to the remittal point. There was, as I say, argument before them as to whether or not there were particular features of this regime that should lead them to a different category answer. So I think
beyond the existence or otherwise of a chilling effect.
Yes,
right.
There were all sorts of, my notes in reply, but there were all sorts of arguments around.
Well, are those
alluded
reflected
to
in the judgment?
Yes.
Court of Appeal judgment.
We'll get you the
to remind me where those are.
And in particular around paragraph 93 and following, because that's where they get into all of
yes.
administrative stage. It's all frightfully unfair. You're doing penalties here rather than market review. It's quasi-criminal. And we had a whole series of arguments around disqualification used in other civil proceedings. We had a whole bunch of arguments around at the category level.
And where do we see the answer to those?
But I think they're analysed in 93 and following, principally. I'll see over the short adjournment whether there are other paragraphs to refer you to on that.
Okay. I mean, the impression I get from the Court of Appeal judgment is that their approach is that this is such a hard-edged rule, they call it a principle, but it's really a rule, that you don't need to investigate in any particular context the actual likelihood that there might be a chilling effect because of the particular circumstances, and anything else that you might throw into the picture about that context is pretty much irrelevant. It's just an across-the-board starting point that the courts have decided to adopt wherever a public authority is acting in the public interest, because there's always a possibility, at least theoretically, when that's happening, that if it has to pay costs, it might not give absolutely fair consideration to whether to take the decision or not.
my lord, if you're putting to me, did they regard this principle from the case law they looked at? Did they regard this principle as being one of real force and weight that applied across the range of circumstances in which the description of the key element from the cases that I drew out applies? Then I think it's fair to say they did regard it in that way.
What I'm asking really is, why should it be treated as of such inherent weight that you don't need to assess in a particular context whether it's a real concern, or for reasons particular to that context is not such a real concern that should justify taking that no cost as the default position?
To which I think the answer is because public authorities operating in this way are and have been acknowledged at the highest level to be different from private litigants and to be supported in this way by this nuanced rule, and because in almost all of the contexts that the courts have considered, they have, no doubt in recognition of part of the difficulty of actually doing the proving, taken to be inherent that chilling risk in all of the three senses that I identified. And for that purpose, BT and Ofcom is very much the outlier. And query how it would have panned out when and if the thing hadn't settled, if chilling effects was going to be the subject of reconsideration at remittal.
Okay, thanks.
Well, that case settled, but have there not been... It was only in 2018, wasn't it? So there hasn't been a regulatory appeal in which a costs issue has arisen since BT and Ofcom.
I think ours.
No, ours is an infringement.
Yeah, oh, sorry, in something equivalent. I don't think there's been anything else. We certainly haven't. None of the parties have produced one. I'm told there is an ongoing appeal, but it's not concluded yet, if that helps.
Just interested in your views about good reason and whether there should be a liberal interpretation of what is a good reason because of what Lord Neuberger said at paragraph 77, page 1300. That is that the understandable resentment felt by a person and therefore the corresponding care when deciding whether they acted reasonably and properly. I just have difficulty in working out how that actually operates in relation to legal points taken by in this type of proceedings, because frequently legal points are won and lost and argued and so on. How do you decide whether the CMA was taking a point which was unreasonable, improper, unless you adopt a fairly liberal approach towards it?
I'm not sure there's a terribly principled answer that I can give to that. Yeah. I mean, the fact of the matter is that there is, perhaps in two stages. First, there is obviously potential for the tribunal confronted with that sort of issue to make that sort of judgment. Your question is how it goes about doing that, to which I suspect the only answer is it will know the nature of the issues, it can bring to bear its specialist expertise for that purpose. Is this the sort of point that really is a sensible point for an authority to be running? Is it a novel cutting-edge point? Is it a point that's been dealt with before and they've produced some rubbishy old answer as to why a different answer should now be given? All of those features will bear. I'm not sure that necessarily, perhaps as the third part of the answer, I'm not sure that necessarily leads to a liberal interpretation of good reason. It just allows them to make proper and sensible and expert judgments about the reasonableness of a course of conduct taken on the facts, and they will bear in mind, no doubt, the disciplines of litigation. And again, from memory below in the Court of Appeal, it was said, I think, principally by Mr. Brearley, well, if you buy into the principle as set out in the Booth line of authority, it's going to undermine litigation discipline. And it will lead to what he described as the kitchen sink approach by the CMA. Well, I think the answer to that is that the jurisdiction of exactly the kind I've just described exists to control that. So it must be broad enough to enable the expert tribunal to make a judgment on that question. Was it a reasonable point or an unreasonable point to be taken? Were costs expended unnecessarily in running a rubbishy old point when they shouldn't have been?
But then, I mean, that begins to become, yes, fall into the unreasonableness test. But I mean, surely there are shades of discipline which can be applied. So clearly, if someone acts unreasonably, well, they know they're going to suffer cost penalties and so on. But isn't there a more general disciplining effect if you know you may be on risk for costs if you lose, that you're encouraged to be rigorously self-critical about your own case before advancing it, whether or not you might escape criticism for being unreasonable at the end of the day?
My lord, there is. And for that reason, CFE is no doubt adopted as a general rule in a large variety of contexts. And because it does have that greater disciplinary effect of the kind that you've described, and no one could deny that. But what we're dealing with here is a balance between the public interest. That pulls one way, but all the features that were identified in the case law pull the other. You need something, even if it does involve some diminution of that disciplinary effect of what would otherwise be the rule. I come back to it. The one thing they've obviously left out of these rules is the CFE.
But just on that, I mean, doesn't that just amount to the fact that the legislator, I mean, here I think it's the Secretary of State that sets the rules, has decided that there won't be a bright line rule, costs follow the event, unlike in Part 44. But might it not then be said that that actually leaves the field clear to the CAT as the specialist body to decide whether there might be categories of case in which it can develop a particular cost practice reflecting its own experience and, if you like, more detailed knowledge on the ground of the way these things are likely to have an impact or not on the regulator and indeed other parties?
Yes, the difficulty with that, of course, is that you end up, which is partly, I suspect, what Lord Neuberger had in mind when he posed the dichotomy he did in paragraph 75. You end up with a very difficult situation if you start trying to say, well, they can do it sometimes, they can do it there, and not there. You end up drifting very quickly, as the CAT jurisprudence absolutely demonstrates. You end up drifting very quickly where that is in effect the rule and the approach, the general rule and approach which is applied by the CAT, to the exclusion of the weight that should properly be given to the regulator position. I mean, that's the difficulty with doing that. I'll come in a second to the significance of them being a specialist tribunal in this sphere, because that's one of my responsive points. But
certainly, thank you.
My Lords, my Lady, I was going to turn, if I may, finally to 3 or 4 directly responsive points. No particular logic in why this isn't included in the numbers, other than we can start again at 1. But in terms of the responsive points, and touching on a point that I've just been discussing with my Lord Sales, there is nothing we submit in CAT Rule 104 to displace the operation or application of the principled approach in the Booth line. It does not contain a general rule of the kind found in CPR 44. That was plainly deliberate, and it strongly suggests, at the very least, that it was positively not the intention actively to remove it or not include it, whilst copying out some of the other bits of the equivalent rules from the CPR, and yet intend it to operate nonetheless as a general rule.
But doesn't that also apply to your general rule?
My Lord, it doesn't, I respectfully submit, and it doesn't because the fact of the matter is that in all of the cases in which the principle has been held to apply, what I describe as the principle has been held to apply, there hasn't been anything in the rules expressly. And so the principle operates in the context of an unexpressed general provision saying do whatever is just and reasonable, as Section 64 did. So you don't have the same inference, as it were, whereas when you've got the analogue of 44, which is plainly in part the basis for Rule 104, and you put some bits in and deliberately don't put others in, there's a much stronger inference from that than the position in relation to the absence, as it were. And I mean, the answer to that, the riposte to that, is that the CMA is the obvious target of the power to order costs under the CAP's rules. But if that's right, then it's extremely striking that the cost follow the event rule was not included. But it doesn't lead, as I say, to the absence of anything equivalent to the principle in the rules, doesn't lead to that same sort of inference.
It was included a bit in C. And do you accept that it would be very odd if costs could follow the event on an issues basis, but not on a totality basis? So I might say that Rule 104 downgrades costs follow the event from being the starting point to being a factor, to be taken into account, and query whether the Court of Appeal's decision is consistent with that. But the factors that you're arguing for don't even make it onto the list of factors to be taken into account, and yet their absence then enables you to argue that they're actually the starting point. I mean, if there'd been two additional factors in the list, one said, oh, take into account, you must avoid a chilling effect on a regulator, take into account that the regulator is acting in a public interest. If those had been there on the list, I think you would have struggled to say that we should elevate them to a starting point.
Unless the rule had been recast so that they were a starting point, at which point you have to grapple with it, and the rule will become rather complicated in terms of its drafting, and I respectfully submit unnecessary, given that the principle has always operated.
Well, the principle has always operated, but at the time that this rule was drafted, it was clear that the CAT was not applying that principle.
Well, we discussed yesterday whether its jurisprudence was entirely clear and set in that respect. But in any event, I submit that if one's trying to get into the mind of the drafter, you've got one alternative, which is that, and the other alternative is that the drafter and legislator can be taken to understand the Booth line of authority. So it's a bit...
There might be a difference there between the kind of completely open-ended provision in the Magistrates' Court rules, for example, where maybe the courts can properly introduce some guidelines, and the CAT rules, which are not completely open-ended, because the approach that the Court of Appeal has adopted in this case, which you're commending to us, seems to read out the bit about taking account of whether you've won on some issues.
My Lord, it expressly...
You don't take that into account in your approach.
My Lord, it expressly doesn't, and the Court of Appeal expressly did not do that.
Well, where does it come in paragraph 79? I mean, unless the conduct's unreasonable, the fact that you've won on the fact that you've lost on an issue is not going to count against you if you're a public authority on your case.
Well, my Lord, if you just take up the Court of Appeal's judgment, I don't want to be unfair to them, take up the Court of Appeal's judgment and go to paragraph 92. Yeah.
Well, how can you reconcile that with paragraph 79, where a good reason will include unreasonable conduct, but it doesn't include whether the fact that you've been reasonable, but have caused costs to be incurred by taking and pursuing issues which you've lost on?
I think it's the mere fact that isn't of itself a good reason. It's permissive. 104 is drafted in a permissive way. And the Court of Appeal has acknowledged, as Sir Igor Judge did in Baxendale Walker, that successful failure can be taken into account, but you've got to start from the right place.
But they're not permitted to take it into account unless, under this rule, unless there is some other additional factor. It's got to be in combination with something else.
Yes, I struggle to reconcile the absolute nature of what seems to be said in 79 with 92. Unless there is a good reason that takes you out of the default rule, how do you get into the 104 rule about looking at success on issues at all?
Well, my Lord, my understanding of the judgment, and I see the principal point being put to me, but my understanding of the judgment is that they were not excluding the possibility that success or failure could be relevant and could be taken into account. But you start, as it were, from the right point. And they say that in terms in 92. They don't entirely accept marry up 79 and 92, but they return to the point in 106. So they were obviously not unalive to it. See second sentence of 106. So they can take into account those factors. They're not being dismissed as irrelevant, and they might operate in combination with other factors, such as financial hardship or any other good reason.
I just assumed from 79(5) that it had to be a combination. Or put it another way, what do you say?
Well, I say that the principle allows for success or failure to be treated as relevant. One needs to be a bit careful with issues-based success or failure, because otherwise you just risk reintroducing CFE through the back door. But they are not dismissing, and we do not dismiss, the capacity for 104(4)(c) to operate.
Does success have to be in combination with some other factor for it to have any weight?
Not for it to have any weight at all, no. But it isn't of itself a good reason.
I have difficulty in following it. I'm sorry. If it's not of itself a good reason, then what part does it play?
Well, my Lord, it can be taken into account amongst the range of other circumstances that the tribunal is thinking about.
So it's a combination.
It's a combination.
Yep.
Yes. In any event, I mean, however it operates in practice, the Court of Appeal are not excluding the operation of that specific part of the rules.
And is that what the rule says? That it is only permitted to be taken into account in combination with other factors, or not? Or?
My Lord, it doesn't say that in terms. It's simply permissive. A non-exhaustive list of factors that they may take into account.
If it isn't itself a good reason, you have to find something else that is a good reason, or is with 104(4)(c) a good reason.
I suppose you could have two half-good reasons, and if you add them together, that's enough to take you over the line, which I think actually is pretty much what you're saying when you accept that factor C can't, in and of itself, you say, be sufficient. It has to operate in combination with some other reason which pushes you in the same direction.
And otherwise, the risk with all of this is otherwise you just end up with the issues-based approach being, in effect, an introduction of CFE through another route, which is not appropriate, we submit. Rule 4, the equality provision, was the other one that was relied upon. And we submit, I mean, to some extent it comes back to the point I was discussing with my Lady Rose about Article 6. Obviously, if Rule 4 equality had been an answer so as to preclude the operation of the principle in this sphere, then it would have been an answer in BT and Ofcom apart from anything else, but it plainly wasn't. What it doesn't preclude is any principled approach of the kind that we are considering. Rule 4 does not carry within its bones the idea that you could not have cost rules that differentiate in terms of starting point or presumption between public and private parties. It does not say that in every respect everything has to apply exactly in exactly the same way.
So there is this difference in applying the equality of arms principle, that when you're dealing with a sectoral regulator and its regulated community, you could expect BT or an energy company or water company to be staffed up with lawyers who understand the regulatory framework, with economists who are familiar with regulatory pricing constraints and that kind of thing. And there's a sort of in-house equality of arms, as it were, between them and the regulator. But even when you've got a big multinational company, a pharmaceutical company, yes, they're going to have lots of lawyers specialising in medical authorisations, patents, but they're not going to have competition lawyers and they're not going to have competition economists. So they start out needing to sort of go outside for advice at a much earlier stage than the CMA does. So there's that difference in equality of arms, leaving aside a smaller SME faced with an infringement investigation. Is that a relevant consideration?
My lady, I've slightly been analysing the Rule 4 and its reach on the basis of precisely the premise that you were putting to me, which is the equality of arms principle and how that would work, for example, under Article 6. And I do respectfully submit that although there may well be differences of the kind that you just identified, those would not be sufficient on any sensible view to put the United Kingdom through this rule in breach of its equality of arms principle, its principled approach on equality of arms under Article 6. The Strasbourg Court, if one analyses it through that prism, would allow national authorities to differentiate on precisely the principal basis that is identified in the run of case law between, on the one hand, the public authority enforcing, and on the other hand, the person who is being enforced.
I wasn't, I must say, looking at it through that prism. I was looking at it more as a general fairness without relying on the convention necessarily.
But there's nothing particularly to suggest, I respectfully submit, just in the bald terms of Rule 4, that suggests that this approach, which after all is based, as Lord Neuberger pointed out, on policy and justice, would fall foul even of the broader fairness consideration. I mean, ultimately, one's got to make a judgment about whether or not this is, whether you analyse it through Article 6 or you analyse it more broadly as a matter of fairness, does this rule, cast in the general terms that it is, exclude the operation of a principle which is based on considerations in the public interest of the weight analysed in the case law? And my respectful answer to that is no.
I just wonder whether, the condition in Rule 4.2 is that you do the things that are set out there so far as is practicable. I was just wondering whether it might be said that, well, if there is a chill effect, which is going to prejudice the public interest, it's not practicable to ensure that the parties are on a precisely equal footing. But then the further thought coming from that is whether that might be indicative that one doesn't just assume that there is that chill effect, such as to allow you to move away from ensuring that parties are on an equal footing, but that you should actually look to see whether there is a genuine risk, either in the category or in the particular case, that there is such a prejudicial effect on the public interest, and that then allows you to depart from the general principle of ensuring that the parties are on an equal footing.
Well, yes, That's quite a big and subtle edifice to build on the word so far as practicable, I respectfully submit.
Right.
I mean, it's not to say that it's not, it couldn't be done. It couldn't be done, but my more substantive submission is that this isn't just about practicability.
Right, but
This is about principle.
it might be said that the CAT, when it doesn't treat a company in the same way as the CMA, is failing in its duty to ensure that they are on an equal footing so far as costs are concerned.
Well, that goes to the meaning of what is implied by equal footing. And my submission is that it isn't necessarily any difference in any of the rules that apply that would breach that principle. But we know from the case law that there are good principled reasons, or one can take from the case law that there are good principled reasons for treating the public authority differently in this sphere. Otherwise, we don't get into this debate. And if that is so, the question is truly whether that equal footing concept covers every form of difference of potential or otherwise difference of approach in terms of any part of this regime, cost or otherwise.
Why isn't the control the words so far as is practicable? I mean, ensuring that parties are on an equal footing looks reasonably straightforward so far as cost rules are concerned. So why isn't then the focus on moderating that, so you move away from a position of equality on the grounds that for some reason it's not practicable?
Yes, well, my lord, I think as long as the so far as is practicable is broad enough to include differences of principle between the public authority and the private litigant of the kind that you've seen in the case law, then I wouldn't be inclined to disagree with that. I mean, again, if you look at it in Article 6,
just so we're clear, that then is the basis on which I was putting to you whether one might say that the appellants get some mileage from this qualifier so far as is practicable by saying, well, it may be practicable if there are reasons of the public interest why one shouldn't apply a pure equal footing regime, but that what's needed to ensure that that is the case is a real risk that there's a chill effect in a given case or a given category of case, rather than a sort of general presumptive risk, which you seem to be arguing for, just because there's a regulator involved and you don't inquire any further.
well, again, my lord, that goes back to the significance of the various limbs of what I described as chilling effect, the encouragement, the capacity in which they act, all the themes derived from the case law. But I would entirely accept that if and to the extent that that bodies are treated differently, private litigant, public authority, whichever way you're analysing it, there would have to be a good reason for doing that.
Yes,
and so if the purport of your question is, does there need to be a good reason, and does that tend to cause one to examine the justification for the operation of the principle quite carefully, query how far one goes down that line, it just takes you back to the chilling effect arguments and the various different ways in which that is put, then I agree. We're not seeking to say there is no sensible objective justification for this, nor that the need to establish that isn't a serious matter.
Thank you.
The second responsive point is whether or not CAT is the significance of CAT as a specialist tribunal. And of course we recognise that CAT is a specialist tribunal. Our submission is that that does not entitle it to adopt a different approach which does not give important weight, we say as a starting point, but on any view important weight, to the fact that the regulator is fulfilling important public functions. And we would add to that, and/or to adopt an approach to costs which effectively excludes the operation of that by interposing a rule which was deliberately left out, namely CFE. And the answer to the appellant's points about this being a specialist tribunal, and it should be the master of its own procedure, is the one given by the Court of Appeal at paragraph 64 of BT and Ofcom, provided their procedures do not conflict with the correct principled approach. And it was held by the Court of Appeal there that they had erred in not attaching the right, or indeed any real weight, to that line of authority and to that fact. That was despite the fact that they were a specialist tribunal. We do also submit that there is much less, if any, space for that approach to specialism to operate in circumstances in which what might be thought we're not really dealing with an area in which specialism truly bears, in other words, costs. That is a matter on which the courts are perfectly able to tell them that the right principled approach is X, Y, or Z. And the fundamental problem with the CATS approach, identified by the Court of Appeal, is that it has never acknowledged, or doesn't appear to have acknowledged, the proper basis for the principle. Regulators operating in the public interest, and as a result have failed in effect to give any weight to that principle. It rejected the principle in the case law analysed by the Court of Appeal in BT and Ofcom on the basis of distinguishing factors which, as the court found, do not in fact engage with or counteract the principal basis on which that operates, the Booth line operates. That links in, and perhaps I can take this as the final point before the short adjournment, it links back into the UK tribunal, the UK-wide tribunal point that we discussed. And I pointed out when we were going through BT and Ofcom that the Court of Appeal there had taken that into account in paragraph 65. They did so with a view to seeing whether there were different approaches in the other jurisdictions, apart from England and Wales, that might lead them to take a different approach. And I acknowledge that in theory, at least, there is the potential for different, particularly different procedural approaches between the different jurisdictions within the United Kingdom. As I understand it, most of these cases start with a decision about forum and which law should govern, and that applies to procedural and indeed sometimes to substantive rules of law. So there is at least that potential. But I made the submission yesterday when I was discussing this with Lord Stevens. I made the submission yesterday. It was in principle hard to see why, if the principle identified in the Booth line of authority is well-founded, it would not be well-founded across the United Kingdom. Put it in Lord Neuberger's language, why would the policy and justice be different? In any event, the UK-wide tribunal point can't lead, we submit, respectfully, to the provision of some form of support to the position that says we'll leave it all to CAT. And it can't do that because ultimately the CAT, like every other body exercising statutory powers, is subject to the control of the courts. You may follow different routes before you arrive here, but you are still, as a statutory tribunal, subject to that control, with the UK-wide position being viewable, and that reflected in the composition of this particular court. And it is for the court here to set what the right approach is in principle. I would add by way of postscript that I'm not sure that there's anything terribly interesting in the case law anyway from the other jurisdictions to indicate any contraindication, if I can put it that way. We found nothing, I'm afraid, unless Lord Stevens and his diligent researchers have found anything in Northern Ireland to help with that issue. There was a case in Scotland that is referred to and analysed by the Court of Appeal in our case, and I've really nothing to add to their description of that case. It doesn't truly advance matters greatly, we respectfully submit, for the reasons that the Court of Appeal gives. Not least, it didn't squarely address the issue and confront it as a matter of principle. And overnight, the diligence of our team has produced a great and good decision by a sheriff in Scotland in the context of forfeiture, so a Perrin-Panathan type context, in which the sheriff applied Perimpanathen and work through that. I hesitate to do, we've sent it to the court, I hesitate to build too big an edifice on this because it is right to point out that both counsel, including counsel for the defendant, appear to have been arguing for the application of Perimpanathen in that context. So at least they weren't the court wasn't confronted with the contrary argument, a bit like Ahmed, weren't actually confronted with the contrary argument that says you shouldn't be doing this at all because you're Scotland and you start from a different position. So the position we respectfully submit so far as this court is concerned, and of course one never says never, one never excludes the possibility of a Scottish case coming before you or a Northern Irish case coming before you in which the point is truly explored, having regard to all the vicissitudes that might exist in relation to costs in those other jurisdictions. The position before you currently is no contraindications to the Booth line in Northern Ireland and none in Scotland either on true analysis because the point has not truly been confronted in either of the cases that you have before you now. And that might be a convenient moment to break. I should say I very much doubt that I will be a full hour after the luncheon adjournment. I suspect I shall be probably closer to half an hour. So,
thank you, Sir James. Court will now adjourn.